Ready, start. The government itself has plainly admitted that one of the grounds upon which the original order of detention was passed is unsubstantial or non existent and cannot be made a ground of detention. The question is whether, in such circumstances, the original order made under Section 3 within bracket 1 within bracket A of the Act can be allowed to stand. The answer, in our opinion, can only be in the negative. We can neither decide whether these grounds are good or bad, nor can we attempt to assess in what manner and to what extent each of these grounds operated on the mind of the appropriate authority and contributed to the creation of the satisfaction on the basis of which the detention order was made. To say that the other ground which still remains is quite sufficient to sustain the order would be to substitute an objective judicial test for the subjective decision of the executive authority, which is against the legislative policy underlying the statute. In such cases, we think the position would be the same as if one of these two grounds was irrelevant for the purpose of the act or was wholly illusory, and this would vitiate the detention order as a whole. There is also no doubt that if any of the grounds furnished to the detainee are found to be irrelevant while considering the application of clauses within bracket first to within bracket third of section 3 within bracket 1 within bracket A and in that sense are foreign to the act, the satisfaction of the detaining authority on which the order of detention is based is open to challenge and the detention order liable to be quashed. Similarly, if some of the ground supplied to the detainee are so vague that they would virtually deprive the detainee of his statutory right of making a representation, that again may introduce a serious infirmity in the order of his detention. If, however, the grounds on which the order of detention proceeds are relevant and germane to the matters which fall to be considered under section 3 within bracket 1 within bracket A, it would not be open to the detainee to challenge the order of detention by arguing that the satisfaction of the detaining authority is not reasonably based on any of the said grounds. It is, however, necessary to emphasize in this connection that though the satisfaction of the detaining authority contemplated by section 3 within bracket 1 within bracket A is the subjective satisfaction of the said authority, cases may arise where the detainee may challenge the validity of his detention on the ground of malafide and in support of the said plea urge that along with other facts which show malafide, the court may also consider his grievance that the grounds served on him cannot possibly or rationally support the conclusion drawn against him by the detaining authority. It is only in this incidental manner and in support of the plea of malafide that this question can become justiciable. Otherwise, the reasonableness or propriety of the said satisfaction contemplated by section 3 within bracket 1 within bracket A cannot be questioned before the courts.